Good evening, everyone. Thank you all for coming to the March 21st, 2023 Public Information Session on Freedom of Information. We have with us Tom Hennick. I'll let Stephanie do the invites, but feel free to ask all the questions you have. It's very informational and very helpful to all of us, and we thank Tom. And I want to thank Stephanie for organizing this and getting us all together. I've done it every time, and every year it's even more interesting. He always makes it new and different and fun. So that's your job.
We'll give it our best shot.
Yep,
right?
so just feel free to ask all the questions you have, because this is very important. It's a law, and I'll let you tell the rest of it. Okay, so Steph, you introduce Tom. Thanks.
Good evening, everyone. Thank you for participating in our Freedom of Information workshop. Please welcome the State of Connecticut Freedom of Information Officer Tom Hennick. Tom will give an overview of the Freedom of Information Act and then be available to answer any questions or concerns that you might have. I know most of you are volunteers, and we all appreciate your time, but there are many important laws to follow with Freedom of Information, and Tom will be the best person to help us and follow along with those laws. Welcome, Tom Hennick.
Thank you, guys. Love coming to Woodbridge. Always fun. We appreciate the opportunity to come out and talk to you, and I talk with you. As Beth said, as Stephanie alluded to, ask questions as we go along. Don't hesitate. Just shoot your hand up or scream them out, whatever works best. We do these sessions not to make you miserable, not to beat you up, but to try to help, to try to give you some tools to work with, so that if freedom of information becomes an issue for you, you're better equipped to handle it. Up front, just so you know, I am not an attorney. I often ask if that's good news or bad news. I don't know how you feel about that. But the reason I share that is that none of this is binding. These are not orders. These are not commands. This is just me giving you advice based on, I'm in my 23rd year at the FOI Commission, what I've seen our commission do, the different decisions that I've read, different changes in the law, working with the legislature, asking a lot of questions myself. So it's based on my knowledge, based on what I've been, sort of told to tell folks, but in no way is it an order. So I could say something and you could say, gee, our board doesn't do it that way. Maybe we'll continue to do it another way, and at least you know what we think on a certain level. The other thing I'll share with you, how many in the room are volunteer board members? A lot of you. One of the things that I often get when I go out and do the evening sessions is, Tom, you don't get it. We're volunteers. We didn't sign up for this FOI stuff. We signed up to help Woodbridge, to help put a budget together. Well, I do get it. Just as an aside, I was on one board in my town for 10 years. I chaired it for the last 5. I was a member of our Board of Selectmen for a couple of years. I filled an unexpired term. So I do get what it's like to be kind of on the other side. And my board, for better or for worse, had somebody who knew a little bit about the law, but many times you're thrust together in a situation where nobody says, FO what? You know what? So it's important that you have a little bit of knowledge so that as you go forward, you're not in a position where FOI is impeding your ability to do your work. You've either been elected or been appointed to a board to try to help the town, and freedom of information is part of it. It's an important part of it, but not at the expense of getting your work done. So I do get that, and I understand when people call and say, gee, we didn't quite get that, and try to help it out and leave you a better position to avoid being, somebody called it the other day, FOI jail. It's not quite that, but just so you get what it is. When we talk about freedom of information, it is the law. It is the law in the state of Connecticut. It's a law that is now 48 years old. It was Ella Grasso's brainchild when she ran for governor for the first time. And if you do the math, 48 years ago puts us right smack in the middle of Watergate. So you had a country that was really beside itself, in turmoil, bordering on a constitutional crisis, much of which was created by secrecy, things being done behind closed doors, things being done where nobody really knew, what else was going on. And Ella was in Congress when Watergate kind of exploded all around us, and she was watching all this, and she's also contemplating her run for governor. And she said, if I run for governor, one of the first things I really think we ought to do is create some sort of an open government law, a law where, our state does not have to go through what I'm watching happen here in our nation's capital. So as you know, she ran and she won, and one of the first things she did was put forward the concept of this open government law. And she put it forward and she said, this is really important to our state. In fact, it's so important that I will see to it that it is approved unanimously by our legislature. Anybody ever watch the legislature? Right? Can you imagine guaranteeing unanimous vote on this law or on anything? Well, folks, she guaranteed it and she got it. I'm here to tell you that I've actually seen a video of the final vote. There wasn't a single no vote in the House, not a single no vote in the Senate. This law passed unanimously. Now, why do I bring that up? I bring it up because it's interesting. It shows you how important it was then, how important it remains today. But it also, frankly, gives us a little insight as to why we have these discussions. Think of the process, if you're at all familiar with the legislative process, think of the process of getting to the point where every single legislator voted yes on a bill that wasn't necessarily, embraced, by everybody. It was going to change the way some folks did business, but yet everybody voted yes. Well, to get there had to be a lot of negotiation, a lot of back and forth, a lot of arm twisting, a lot of, I like this concept, not that concept. So you've got a law that's based on a simple, easy concept. This is a quote that I like to share. This is James Madison from the mid-1700s. A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy or perhaps both. A people who mean to be their own governor must arm themselves with the power which knowledge gives. For democracy to work, people need to know what's going on. So it's based on that concept, but then you look at it and say, okay, I get it. Now what am I supposed to do? And you try to read it to tell you whether you should be in executive session or whether there's a record you should give out. Has anybody tried to read it? I bet a couple of you have. Even one paragraph. Your eyes roll to the back of your head. The wherefores and the whereases and your intuition takes you here and the law seems to take you there. That's because to get to that point where everybody voted yes, they left a lot of, for lack of a better phrase, gray areas. And they left us in a position where those of us who are on the front lines have to be able to make a call, have to be able to interpret the law, sometimes on the fly. You're at a meeting and choose, so the idea behind this is to have the discussion to put you in a position to make, if not the right call, the better call, so that you're never in a position, I shouldn't say never, so that you're not in a position to have to constantly defend yourselves against freedom of information issues. The law is not intended to do anything other than to make, our governmental relationship with the people better, but sometimes you're put in a box, and what happens is people don't like the way you've handled something under freedom of information, and they file a complaint against you, and the goal would be to put you in a position so that complaints are few and far between. Now, Woodbridge doesn't have a bad record in that regard, so, so far, but it's better to make sure that you're well-informed and that you have the tools to work with. So as we go forward, ask questions, happy to answer them, and by the way, I'm never afraid to say I don't know. I'll ask you to give me a phone number or send me an email, and I'll try to get you an answer and put you on the right path. The law, one of the first things I always tell people is that the law is called freedom of information, but it's not really about free information. Freedom of access would be a better title. Access to public meetings and access to public records. But freedom of information, I guess, sounds better, So one of the first things I tell folks is it's not really about free information. Those of you who work in town hall, I bet this has happened to you. People call up or come in and say, under freedom of information, I have a right to know. I was in Marlborough earlier today, and for some reason that's like a runaway train in that town. They've got people running into the town hall. Freedom of information. Tell me, why did they do this and how did they do that? Well, nothing in this law requires us to answer questions. It's about access to meetings, access to records, but people come in and ask questions or call us on the phone. We're going to answer them, right? We're public servants. But at some point you may think, I'm not comfortable answering that question, or we don't really know the answer to that question. They should go to the meeting where the issue is being discussed, or they should get the records where that information is contained. And that's what you have a right to do. The law doesn't require us to be the answer people. And so, one of the first fundamental lessons is it's not about answering questions. It's about providing access so that they can participate in the governmental process, be aware of what's going on, but we're not their researchers. That's not what it's intended to be. Just as an aside, if that's ever been an issue for any of you, people asking questions, I see, I know people walking the police department all the time. I saw the cruiser in my neighborhood last night. Why were they there? Stuff like that. People say, how far do we go? You have to, you know your people, you know what you're going to ask, but think about working where I work at the Freedom of Information Commission. I spend a lot of time on the phone answering questions about freedom of information, but a lot of other things too. People think that we're like the information center for the whole state of Connecticut. People call up with questions. Some folks have said, Tom, stop doing the FOI thing and tell stories about people who call you up, I've had people call up and ask for directions. No, that's not what I actually had people call up and ask, true story, how do I get tickets to tonight's UConn game at the Civic Center? No, that's not what we're there to do. And when it comes to records, people think that we have possession of every single record held by every single agency in the state of Connecticut. People call us up and ask us to send them your records. A couple weeks ago, an attorney called, and said, she was very excited. She said she found out that her client's accident had happened in a parking lot that was owned by the state of Connecticut. And she says, this is great. Can you please send me the surveillance video from the parking lot? No, I don't sit in the big vault with every record and push buttons and out it comes. Our role is to ensure access, so there are lessons to be learned. We have to tell people what the confines of the law are. So access to meetings and access to records. Here's the definition of a meeting in the FOI Act. Meeting means any hearing or other proceeding of a public agency, any convening or assembly of a quorum of a multi-member public agency, and any communication by or to a quorum of a multi-member public agency, whether in person or by means of electronic equipment, to discuss or act upon a matter over which the public agency has supervision, control, jurisdiction, or advisory power. The short version of that, guys, is that if you're on a board and the board's going to meet, make sure you've done a couple of things. Make sure it's properly noticed, make sure it's open to the public, and make sure there are minutes of the meeting when the meeting is done. Now, what do I mean by properly noticed? You have to have an agenda that's available at least 24 hours in advance in the clerk's office and in your board's office if your board has an office. And then you have to make sure that that people know where the meeting's going to be and to make sure the agenda's clear. And then the law talks to us about 3 different kinds of meetings that we can use. And we have a regular meeting, we have a special meeting, and an emergency meeting. Now, regular meeting comes per schedule that you've submitted. I hope all of you are on boards, have your schedules laid out for the year. We meet on the 1st and 3rd Tuesday, the 2nd and 4th Wednesday, Town Hall 7 o'clock, Library 6 o'clock, whatever that is, that's your regular meeting schedule. Then there's the special meeting, and a lot of people see that word special and they get spooked. They say, special meeting, we can't do this, you can do anything you need to do at a special meeting. Here's the fundamental difference. I mentioned the agendas. The agendas need to be in 24 hours in advance. Anybody here an agenda preparer? Anybody responsible for that? A couple of poor, unfortunate souls, right? Remember that the agenda, the courts have told us that the agendas need to fairly apprise the public as to what's going to happen. So you put everything on there as clearly as you can so that I can look at that agenda and say, okay, I need to go, I don't need to go to that particular meeting. So the agenda's in 24 hours in advance. At a regular meeting, should something arise that's not on that agenda, a board can vote to add items to the agenda by a 2/3 vote of those present and voting. But at a special meeting, and here's the difference between the two, at a special meeting you can only talk about what's on that agenda. So when I push you to be as specific as possible on your agendas, that's why. At a special meeting, you can't talk about what's not on there. So I don't know about you, but I cut and paste when I do an agenda. Other business, old business, new business, I slap them on there. But for a special meeting, if you have an item like other business on there and nothing is articulated underneath, you might as well take it off, because you can't say, is there any other business? Whereas at a regular meeting, the chairman can say, is there any other business? Somebody raises a hand, yes, Mr. Chairman, I'd like to add this. Motion made, seconded, 2/3 of you vote to do it, you can add it. But otherwise, the special and the regular meeting are almost identical. You can do anything you need to do at either one. The meeting's really only special because it's not at your regular time slot and your regular date. That's really the only thing about it. So you want to make sure that, again, agenda preparation is key to making sure that you're following the law. The third kind of meeting, the emergency meeting, folks, is a meeting that I really discourage boards and commissions from using. Emergency meeting is unnoticed, and the legislature really doesn't want us to meet without notice, if at all possible. And the problem with the emergency meeting is that what you and I think might rise to that level doesn't necessarily rise to that level in the eyes of the law. The story I like to tell is, we have some holidays in Connecticut. And in some towns, town halls are closed, some are open. I'm thinking Columbus Day, Veterans Day, Lincoln's birthday is a state holiday that nobody knows about. And a lot of times I'll get a call the day after one of those holidays and somebody will say, "Hey, Tom, I've got a problem." What's the problem? Our regular meeting is tonight. It's on the schedule tonight. I always bring the agenda in the day before. I forgot town hall was closed yesterday. So I brought it in this morning. Is that okay? No, it's not okay. It's not 24 hours. It's pretty strict, 24 hours. Well then, we've got too much to do, and those of you who are on boards know what I'm talking about. We've lined up a big meeting, too much to do. We have to meet tonight. I'm calling it an emergency meeting. And my response to that is, look, please don't, if you want to stay out of FOI trouble, oops, I forgot it's not an emergency. Now think about it in our non-legal minds. It's an emergency. We got to get this work done, but the law doesn't look at it that way. So you really want to stay away from the emergency meeting if you can. A lot of people say, well, what the heck could happen? What's the big deal? I often share, and some of you may have heard this already, the story, a town not all that far from here had a situation where the assistant fire marshal thought he was about to become the next fire chief. He was very excited about this until he found out that the rumor was false. So he comes barging into the first selectman's office on a Friday afternoon, and I am told they had a beauty, screaming, yelling, things getting knocked off desks, cursing, the whole thing. First selectman calms him down. He's known this guy for years. He calms him down. He says, look, you're not going to be the next chief. I'm sorry. We're going in a different direction. But I tell you what, because you've been here so long, I'll ignore all this, and I'll make you the interim chief while we look for a new chief. He's not happy, but fine. Well, it's a small town, like yours, like mine, like most of the towns in Connecticut. It doesn't take very long. Word gets out fast. The phone starts ringing off the hook. The emails are flying, and this is terrible. This is awful. He was insubordinate. He was unprofessional. He was threatening you. He was a danger to you. You got to do something about this. First selectman thinks it over, and he says, well, He calls his board together the next morning, a Saturday morning, for an emergency meeting to discuss the issue. They talk about it. They decide, you know what, the guy's no good. They fire him. He's out. They go to find him because it's a Saturday, and he was evidently like cleaning his gutters or something, so they haul him off his roof. He's got the leaves hanging out of his hair, the whole thing. They bring him down to town hall. Thanks for coming in. You're fired. He gets furious all over again. He's screaming and yelling, you blankety blanks can't fire me, da-da-da. Besides, I'm quitting. So he marches out, and they reconvene the emergency meeting and accept his resignation. All right. So well, remember, I alluded to the fact that if people don't like the access that they're given by this law, they can file a complaint against the public agency with the FOI Commission. So this guy says, you know what, that wasn't right. There was no emergency there. I'm filing a complaint. So he files a complaint with the FOI Commission about this meeting. The commission looks at all the facts and decides, you know what, this wasn't really an emergency. They just didn't want to have him around while they had this discussion. At least that was the commission's interpretation. And they find against the town and declare null and void what happened at that meeting. So now he was fired and or quit at a meeting that didn't happen. Could be the end of the story, except if you don't like a commission decision, and this speaks to the idea that things are so interpretive, you can appeal an FOI Commission decision all the way to the Supreme Court. So this guy, commission finds in his favor, but the town appeals it, takes it all the way to the Supreme Court. And when it finally gets there, and finally is a key word in this story, the Supreme Court upholds the decision of the FOI Commission and says, we also found that that was not an emergency, and we concur that that meeting is declared null and void. Is the HR person in the room? What's our problem? Anybody know what the problem is? Well, to get to the Supreme Court isn't a matter of days or weeks or months, it's years. So 4 or 5 years later, this guy is being told that he was taken off the payroll improperly because the meeting never happened. So now they've got a real mess on their hands. It took them literally another year and a half to figure out how much money they owe the guy in back pay, all because they didn't wait 24 hours. This is an extreme example of what could happen. But I want you to kind of file it away and say, okay, maybe it's not such an emergency today. We'll wait 24 hours, because once you wait 24 hours, you've followed the law. If you ever have an emergency situation, which you might, I hope you never do, but if you do, you have the meeting. Within 72 hours, create minutes. First of all, talk only about that emergency situation. Within 72 hours, create minutes that reflect what the emergency was, who was there, and what you did about it. But again, if you can avoid the emergency meeting, that would be better. Yes, sir.
Yeah, thank you, Tom.
Sure.
What do you, in the case of an unnoticed meeting that goes ahead and happens, what's the recourse? What does the FOI commission do
Well,
in that case?
we declare it null and void, and everything that happens can get wiped out, number one. But if you have an improper meeting, let's suppose you have an improper meeting and you realize it. Someone calls me about it. By the way, if these folks had called me back then, my advice would have been stop the music, notice the meeting again, do it properly, and the complaint could go forward. You'd be told you did it wrong, but there'd be nothing else to do. It's because it just the matter would have been resolved. The FOI commission can also issue civil penalties against boards and commissions, anywhere from $20 to $1,000. Doesn't do it that often, but if it's found that it's a particularly egregious violation, that it was clearly an attempt to keep the public out, the board members could be fined as well. Your meetings are open to the public. Anybody can come. Hey, you're from Bethany. What are you doing here? It doesn't matter. Anybody can show up. Anyone can audio or videotape a meeting. Now, that's not as big a deal as it used to be, because we do a lot of that now and with our electronic meetings, but that's still in the law. Here's a piece that a lot of people aren't aware of. Nothing in the FOI Act guarantees anybody the right to participate in a meeting other than the board members. In other words, public speaking is not guaranteed under FOI, and a lot of people think that it is. They come into the meetings and they want to talk and they want to have something to say. Now, most boards, the majority of boards, have public comment. Some have 2 or 3, periods of it during a meeting. Fine, but understand that it's not required. And the important thing there is, you get a meeting, the house is packed, and you're looking out there and you're thinking, if we let everybody, speak as long as they want to, we've got a problem. 2-minute limit tonight, 3-minute limit tonight, or we've talked about this topic 100 times, we're not talking about it tonight. The board has that kind of control. The board has the ability to run an orderly meeting and get its work done. I'm not discouraging public comment or anything like that, but you do have a level of control that allows you to move forward. You may have things in different charters and different bylaws that require it, but if you don't have public comment on a given night, you're not violating FOI. That's the key piece that I want to share with you. And now's a good time for me to sort of veer off for a second. Are we back meeting mostly in person in Woodbridge? For the most part? Well, as you know, when COVID hit 3 years ago, and it's really like about 3 years ago today almost, that everything shut down. First, the governor issued an executive order, then the legislature stepped in 21 and 22, and the upshot is that we are allowed to meet totally in person. We are allowed to meet in a total virtual fashion, or we meet in what they call hybrid, which is a little bit of both. You're probably familiar with all three, but the ability to do that came with some extra rules, courtesy of the legislature. Number one, if you're going to have a hybrid component or a totally virtual component, you need to make sure that notice gets out at least 48 hours in advance, not the 24 hours that the agendas do. So at least 48 hours in advance, you get the word out. Your board members know, the public knows that there will be a virtual component to this meeting. I don't know why they wrote it this way, but the agenda still is only due 24 hours in advance, but a lot of people said, the heck with that, we're just going to do it all 48 hours in advance. That's certainly fine. There's nothing wrong with doing it early, but at least 48 hours in advance, you get the word out to everybody that that's what you're going to do. then the agenda has to have the link. I don't know whether you use Zoom or WebEx or Teams or whatever you use. The agenda, at least 24 hours in advance, must have the link, and you must be able to put it out there. And if it is a regular meeting only, and it is a regular meeting that is done completely in a virtual sense, the law requires you to record that meeting, to put the recording on your website within 7 days, and to make sure that the website recording stays up for at least 45 days. Now, again, there's some confusion there. I misspoke the other day because I got confused. That's only for regular meetings, and it's only for regular meetings that are totally virtual. Special meetings don't count, nor do hybrid. Now, a lot of people are putting more stuff up. That's certainly fine, but to comply with what they've put in the law, it's those regular meetings and the recordings. Has Woodbridge been hit at all by Zoom bombing? Has that happened here at all?
No.
All right, knock wood on that. You know what I'm talking about when I say that, right? That was a big problem in the beginning. And I personally have found that when people are on the screen as opposed to being in the room, they're a little more emboldened. They're a little more empowered. And they start saying things that perhaps they wouldn't say if they're sitting here. I know it's a nice town here, but every once in a while, maybe somebody gets a little The point there is, just because someone's on the other side of the screen doesn't mean that you have to give them more latitude than you would if they're in the room. Yes, you have to create that virtual access for folks, but if they get out of hand and they're disrupting the meeting, you can mute them and kick them out the same way you could kick them out of the room. And that's kind of an important thing to put in the back of your minds. I hope it never happens, but I don't know. I just find that people feel that they're empowered to say more. I'll tell you one Zoom bombing story. You might get a chuckle out of this. It's happened to me once since all this has been going on. And I'm much more comfortable in person than on the screen. But it was sort of at the height of the pandemic. My oldest daughter is an international teacher. And during the pandemic, she couldn't get to her country, which was Panama. She couldn't get to Panama. So she's teaching the first graders in my dining room downstairs. And I'm upstairs doing an FOI talk, about talking FOI. And all of a sudden, we hear this loud kind of reggae kind of dance music, Where's that come? And I figure it's the first graders, so I go to, and she yells up the stairs, "Dad, what's that music?" And I'm thinking, oh, it's not the first graders, it's me. And as I turn around, I look at my screen goes black. And the strippers parade across the screen as I'm talking about freedom of information. They left very little to the imagination. Now, if they wanted to stay and listen, they could have, but they were disrupting the meeting, so we kicked them out. Anyway, again, you don't have to put up with that's a funny one, but some of them got really serious. I mean, we're talking about racial epithets. We're talking about people being really insulting. Bristol had a case a couple months ago now where a planning and zoning meeting was disrupted. They've got a site plan up on the screen, and all of a sudden the site plan goes down and the pornography comes up. I mean, and they had to stop the meeting. It was really awful. They got law enforcement involved, and it turned out it was some kid in Maryland. It wasn't even anybody who had even the remotest interest in what was going on. So, consider yourselves fortunate. I hope it never happens. But the point there is, it's happened, and understand that you're allowed to shut it out. You don't have to allow that to continue. You have a right to run an orderly meeting. So the law talks about openness, and I'm pressing that, but there are a couple of paths that boards and commissions can take to exclude the public. If I say executive session, does everybody know what I'm talking about? Remember, folks, that an executive session is a portion of a publicly noticed open meeting. It's not something that sits on an island by itself. So even if you have an agenda that's only one item deep and it's an executive session item, you still need to notice the meeting properly. You need to convene it in public. You can't imagine the number of times people have called up and said, well, we only have one item tonight, it's executive session, so we're not going to notice it. No, at least they thought to ask. No, you can't do that. It's still an open meeting. So you convene in public. Someone makes a motion to go into executive session for one of the 5 reasons for executive session. Motion, seconded. If 2/3 vote to go in, you go in. You have the discussion, you come out, and you vote, and the minutes need to reflect precisely what the vote was, who voted for what or for whom, and then you adjourn and go home. But it's part of an open meeting. So the 5 reasons, first of all, a personnel matter. Personnel matter when you notice it, first of all, has to say more than just personnel. The courts have come down pretty strongly on that. Executive session personnel, discussion of the performance of a town hall employee, discussion of the performance of a teacher, discussion of the performance of a police officer. You don't have to name the individual, but you need more than just personnel. Then it's important that you remember that the person be notified. And that could be one of you, but you're notified, we're talking about you in executive session tomorrow night. The person then has the right to come forward and say, no, you're not. I do not want that discussion to be held in an executive session. I want that in public for everybody to hear. And if the person insists on that, you cannot, as a board, go into executive session. Where there's confusion is the person waives that, says, no, I don't want it in public, but you're going to executive session, damn it, I want to be in the room. And intuitively think about that. You're talking about me, I get to be in the room. But that's not what the law says. So once the person waives that, it's up to the board. The board has every right to invite in whomever it wants to any executive session, to give evidence, to give testimony, to hear somebody's side of the story, to use their expertise, but it's never required. So occasionally I get a call, they said they're talking about me and they wouldn't let me in the room. If they did it properly, they gave you the right to do it, it's okay. Executive session number 2, pending claims and pending litigation. There's a lawsuit. Now this gets a little tricky because you need more information than just pending claims, but the reality is sometimes putting more out there might tip your hand. It might make it clear what your strategy is going to be. You don't have to ever do that. So you can sort of work around executive session plan, discussion of the Jones lawsuit. Just, things like that. You got to have more than just legal matter, but it could be a grievance, it could be a FOI complaint, it could be a CHRO complaint, but you can't just have legal matter on there. Number 3, a security matter. I got to be honest, that one never used to come up very much in the beginning of my FOI career. But around 2012, when Sandy Hook happened, that executive session started popping up a lot. First with boards of education, then boards of finance, boards of selectmen, town councils. How do we keep the kids safe? What do we do to keep the kids safe? If you think about that one, going into executive session makes sense. Why would you have the discussion in a public forum on the off chance that the person who's going to do the, trying to get in is sitting out in the audience? Another one that's come up in that vein recently is cybersecurity. I don't know if you've read it or heard about it. Plainfield, a couple months ago, the whole system got hacked. They were shut down for weeks. And they had to have, meetings. And again, think about it. You're talking about figuring out why it happened and what to do to prevent it going forward. Why would you do that in an open forum when the hacker could be sitting in the audience? So again, that one holds the same. An executive session for a land transaction. The town's going to buy a piece of property, sell a piece of property, lease a piece of property, and it wants to negotiate that, discuss the terms. Again, that makes sense if you think about it. Why would you do it in public? Oh, look, the town's offering this, we'll offer another 10 grand and we'll get the property and the town won't get it. Or the town wants to sell it at this, it can work to your disadvantage to negotiate something like that in public, so you could do that in an executive session. Reason number 5 is a little broader, it's a little less defined. It allows a board or commission to talk about a document or documents that it believes are exempt from disclosure. So let's suppose you're on a board that puts a project out to bid. This is a pretty good example. There's an exemption in the FOI Act that says you're allowed to withhold the content of a bid or an RFP until you've actually signed the contract. So you're a board of education, you put your transportation contract out to bid, and DATCO submits a bid, and First Student submits a bid, and all the different bus companies submit bids, and you want to look at them before you decide which way to go. You haven't released them because they're exempt, at least until you've signed a contract, so you go into executive session to talk about the content. Another example, you are a board, you seek a written legal opinion from your attorney. You're now the client, so the written legal opinion is covered by the attorney-client privilege. You're not going to share it with anybody. You would go into executive session to talk about the content of the written legal advice that your attorney's given you. Those are just a couple of examples of how that one might work. Again, I stress executive session. Discuss as long as you want. Please don't take any action. You don't want to have it on the record that you came out of executive session and said, well, we just decided to, which means that you've taken action behind closed doors, and that's not proper. In addition to executive session, the law creates couple of areas that make it very difficult for someone like me to try to explain, but I read you the definition of a meeting. The sentence that follows that in the law says meeting does not include. Meeting does not include. There lists then a number of things, every single one of which we would call a meeting. Sitting in this room, we say, gee, that sounds like a meeting. Legislature said, swell, you can call it a meeting if you want, but for the purposes of FOI, it's not a meeting. You may have heard the term non-meeting floated around. It makes me crazy because you're sitting, you're having a meeting. It's a meeting that's not covered by FOI, but it's still a meeting. Top of the list, executive level search committees. A police chief retires, a superintendent of schools retires. You form a committee to look for someone to take that person's place. That committee can operate outside of freedom of information. All that we've talked about, they don't have to follow that. Collective bargaining. We have unions in Woodbridge?
Yes.
Yeah, okay. All collective bargaining, strategy, negotiations, things like that, not meetings. You want to go down to Pepe's and negotiate down there, you can do it. It doesn't matter, you have to tell people where you are, what you're doing. Not meetings. One that I get a big kick out of is you're allowed to have a chance meeting or a social meeting, neither planned nor intended for the purpose of discussing matters related to official business. You're all friendly. You have a nice meeting, and you want to go out for a drink afterwards. So it's a chance, it's a social gathering. You're not intending to do business. I know we're recording this, but I'll take a chance here. What the hell else are you going to talk about? Right? I mean, are we that naive to think that you're going to go from a meeting to a bar and not talk a little bit about? I'm supposed to sit here and tell you never talk about board business in a situation like that. But the reality is it's going to happen. My strongest advice is to remember that it's not supposed to happen. So talk about, gee, did you see the outfit that person had on? Or rehash something that went on you know what I mean? Keep it on the surface level. Because I guarantee you the one time you lose sight of that and get into a hot debate about the big topic that's in front of the board, the wrong person sitting in the next booth and says you just had an illegal meeting and you're vulnerable to a complaint. Be really smart the level that you bring those conversations, and do not set the budget over the eggnog at the Christmas party. Be really smart about how you gather in a social fashion. Also in that category is the caucus. It allows members of the same board and the same party to have conversations. You want to be careful there because a lot of times a board will caucus appropriately and then say, well, let's bring in the town chairman to chat with us. Once you do that, it's not a caucus anymore. So if you're going to use the caucus provision, same board, same party. And, just understand that when we talk about meetings, if you remember from the definition, there's a phrase in there that said whether in person or by means of electronic equipment. How do we communicate today? We email, we text, we Twitter. Well, that's electronic communication. So this idea of, well, we'll do it via email, and the chairman sends out something and says, this is what I think we ought to do, and I want everybody to read this. Well, that's okay. But the next step, when you write back and say, that's the dumbest thing I've ever heard, and you write back and say, no, I really like it, and the next thing you know, you're having that debate via email, don't do it. You've got almost, for lack of a better phrase, double jeopardy there. The emails become public records. When we talk about records in a minute, you'll see that. But what you're thinking and what you're talking about, if somebody wants to see those emails, you'd have to release them. They'd say, oh, wait a minute. There was a quorum of the board on this conversation. They had a meeting via email and it's a secret meeting. Again, you're very vulnerable to a complaint. Always think in terms of doing your work in public whenever possible and making sure that as best you can, you don't cross the line. Obviously, it happens. We are not, we don't have eyes and ears everywhere, but the idea is to do your work in public so that democracy works. The last thing about meetings is minutes. Any minutes takers in the room? I feel your pain as well. For many years, I did the FOI Commission meeting minutes, only recently relieved of that duty, thank God. But here's my advice on minutes. They need not be the recreation of War and Peace. They are not meant to be this lengthy, great American novel, on and on and on. They're not a verbatim transcript. The only technical requirement for minutes, is a record of the votes. Who votes for what or for whom. Other than that, it's up to you. So when people stand up at the meeting and they say, I want every word of this in the minutes, it's not required. And he said, she said, back and forth, not required. It's entirely up to you how much you put in there. So think in terms of a crisp, clear, concise recapitulation of what happens. Get the minutes done, get them in within 7 days as required, and move on to the next event. You don't want to make minutes so burdensome that everybody's going crazy. Now, I had a call today from a state agency, and this woman is doing the minutes for this new subgroup. By the way, I didn't mention this. You know, a lot of people say, well, we'll form a subgroup, and that's not subject to FOI. Wrong answer. When you read the definition of a public agency, which is really long, it has, I won't read it to you, but there's a phrase in there that says including any committee of or created by. So I sometimes get calls from people who want to sort of dance around FOI. Our 10-member board is going to form a 4-member subcommittee, so then we're not going to worry about it. When I hear that, I get very nervous, by the way. I know they're vulnerable. The 4-member subcommittee becomes a new public agency that needs to follow the same rules we've been talking about. But the woman today called up and said that she was doing the minutes. It's a new subgroup, and the chairman wanted to take the minutes and share them with everybody and have everybody correct them before they sent them in. I said, no, because first of all, you're the minutes taker. You take them and you put them in, 1. 2, by doing that, she's having an illegal meeting. She's having them all check the minutes and making their changes. And so, you know, try to make it as streamlined as possible and get the minutes in. There was a question that was raised about documents that are submitted to boards, commissions, and things like that, or that the board's going to use like a packet. I don't know, when I was on the Board of Ed and the Board of Selectmen, we got a packet. Is there a requirement that those things be posted beforehand? What's their availability beforehand? There is none. At the height of the pandemic, when we were all, you know, online, that was a requirement, but that was removed. Now, obviously, if you're a board and you know that it's a document that everybody's going to want to see, you might want to make some extra copies so that there's not a stampede when the meeting begins. But there's nothing in the FOI Act that requires that. There's nothing that requires you to put anything online, anything like that. The only online requirement for FOI, obviously with the electronic meetings, but if it's an in-person meeting, special meeting agendas have to be online, but that's it. We put more and more online now. That's great. It's the more that's on there, the easier it is. I think people are stop calling, they stop coming in, they can find it there, but the requirements are not that stringent. Before I give you a little bit about records, are there any questions about meetings that I didn't touch on? Anything you wanted to ask about? Look at that, Steph. They're on it. You got one?
I just want to make sure that everybody knows that they're required agendas and minutes for every board and commission and subcommittee and ad hoc committee and committees. Those are all required minutes and agendas.
Right.
And motions, the motions too.
Well, the motions thing,
The motions
the law says that there has to be a written record of the votes after 48 hours. That's not necessarily a formal document. So my recommendation there is to take an agenda and mark it up as the meeting's going on and make sure it's available either in your office or in the clerk's office. So that if somebody says, how did they vote the other night after 2 days, you can read it off and you know what it is. That's not something that has to be posted or filed or anything like that. It just needs to be available. Anything else? Steph, do you have any meeting questions? Beth? No? All right. So we could spend a lot of time on the records provisions. I'm going to try to brief it down. There's a chance that I might not hit on what you're interested in. So please ask. I don't want you to go home thinking he didn't talk about it. I want you to ask. But the basics of the records provisions. I'm going to read you 2 pieces of a definition. Public records or files means any recorded data or information relating to the conduct of the public's business, prepared, owned, used, received, or retained by a public agency, or to which a public agency is entitled to receive a copy by law or contract, whether such data or information be handwritten, typed, tape recorded, videotaped, printed, photostated, photographed, or recorded by any other method. The second part goes like this: except as otherwise provided by any federal law or state statute. All records maintained or kept on file by any public agency, whether or not such records are required by any law or by any rule or regulation, shall be public records. And every person shall have the right to inspect such records promptly during regular office or business hours, copy such records in accordance with Section 1-212, or receive a copy of such records in accordance with 1-212. So if you heard the words, I read it fast, but if you heard the words, I basically told you that every record held by every public agency in the state of Connecticut is defined as a public record. And in theory, anybody could walk into this town hall or walk into one of your board meetings and say, I want to see that record, or make a request for a copy of that record. If it were that simple, class dismissed, we're going home. The problem is that on top of those basic definitions, we have what we call in freedom of information 3 E's. There are exceptions, there are exclusions, and there are exemptions to disclosure. Now, before you start throwing things and saying, why do you tell us everything's a public record? And that, because all too often people who do what we do lose sight of the fact that everything's a public record. We tend to get possessive. Their Board of Ed records, you can't have them. Their First Selectman's records, you can't have them. Their clerk records, you can't have them. We also get selective, don't we? You look like a nice guy. We'll give you the records, but you look very suspicious. You get nothing at all. And you used to be a reporter, you've been here too much, out. You would think that after 48 years that didn't happen anymore. You would think that people would understand that it's not about who's asking or what department the records are in. It's the content of the records. They're either exempt and withheld or not exempt. But it's human nature. I know this is a nice town. You don't have any difficult people to deal with. But we all have difficult people to deal with. I say that with tongue in cheek. We all have them. At FOI, we have them. We have one guy between 2011 and 2016 filed more than 450 complaints against various agencies around the state. We reached the point with him where he's making us nuts. He's still got us tied up. That's 7 years ago. He's still got us tied with lawsuits and this and that. He files complaints. We stopped hearing them because so many of them are outrageous. We took the extraordinary step. Now remember, we're the open government people of telling him that he had no claim, go away. But even when he comes into our office or writes to us and asks us for a record, a young guy who's going to help me with all this, today and yesterday spent a couple hours putting together a records request for him. We have to forget who it is. We have to forget what he might do with it, or trying to figure out what he might do with it, and say, if it's exempt, no. If it's not exempt, give it to him.
And you can charge for the
Well,
document sometimes.
remember, so the question is often this, all right, this guy comes into your office, or your guy or woman comes into your office and makes a massive request. Have we had any of those? These massive requests where they
We just had one.
pile of it? What do you do? My first piece of advice is this. Try to have a conversation with the requester. You would be surprised, even the difficult ones can be talked off the ledge. You've asked us for all of this. Listen, we'll get it for you. Whatever's not exempt, you're welcome to it. But can we narrow the scope of the request? If we do that, it'll take us less time to produce what you need. You'll find out what you need that much more quickly. And oh, by the way, to Steph's point, it'll cost you less money because the law says that you can charge up to 50 cents a page. And if it's paper documents and it's 50 cents a page, it can add up really quickly. And if the cost is going to exceed $10, you can get your money up front. So you tell the person, look, we'll give you all this, but it's going to cost you $225. And whoa, wait a minute, I don't want to do that. And you can maybe, and then it's clear that you're not trying to hide anything because the majority of times you're not. You're trying to follow the law, you're trying to be transparent, and you're trying to help, even if it's a difficult person. But then the question comes, okay, what happens if they won't back down? What happens if they insist on all of this? We've got a lot of work to do. We've got other things to do. Remember a couple of things. Nothing in the FOI Act requires a public agency to produce a record immediately. I suspect you've had people over the years who have come in, I want it and I want it now. I need it now. I have to have it now. Give it to me now. It's a public record, that sort of thing. And by the way, there's two ways that people can get records. In case it wasn't clear, they can either ask to inspect a record or get a copy. A lot of times the people who want to inspect figure that because you don't have to make a copy, you can produce it right away. But what I'm about to say applies to both inspection and making copies. There's no requirement for immediate, I mean, obviously, if it's an agenda that's sitting right on your desk, you're going to give it to them. But you say, no, not immediate. Well, how long do we have? The FOI Act says that you need to produce records that are not exempt promptly. Anybody want to take a crack at that? What does that mean? Well, it went to court very early in the life of the law. The court said, we've got your back on this. Promptly means without undue delay. All right, now, I don't know about you. I would like a deadline. I'd like somebody to tell me you got a day, a week, a month, a year, whatever it is, but we don't have that. On the other hand, promptly is kind of open-ended. Only you know where the records are kept. Only you know that it's a 3-person department and one of them's out sick and one of them's on vacation. Only you know that it's election time or it's tax time, or you know what I mean? So you look at the request, it's a big request, they're not budging. Okay, we can legitimately give that 2 hours a week without throwing the whole thing into turmoil. And at 2 hours a week, we can get you your records in 4 weeks. And of course, the reaction is going to be, 4 weeks. Now, I'm not telling you got 4 weeks every time somebody makes a request. But if you're looking at it on the whole, and you're thinking, this is what makes sense to me, and this is legitimate, and you'd be prepared to defend that should they file a complaint that you're not being fast enough, then that's your answer. Then it's 4 weeks. Do not be afraid to give an honest answer. We'll do the best we can. We think 4 weeks is legitimate. They may not agree, but again, if they file one of those complaints and you have to go to Hartford to defend it, and you're confident and you're comfortable that that was a reasonable response, then you're going to be okay. It's one of the things that it's hard because a lot of times people will put pressure on you. They'll try to bully you. And we don't encourage that, but that's what happens. Remember, too, that you never have to create a record that you don't have. A lot of times people will come into a police department, a town hall. I need a list of this. I need a report on that. If you don't have it, you're not required to create it under FOI. You're also not required to do research. A lot of people, Stephanie runs into this a lot. People come in and they want her to do, the whole land thing for them. Not required under FOI. Access to records that exist, that they can identify. If they're exempt, you pull them back. If they're not, you give them out. We have a lot of records electronically today. Don't shoot the messenger, but the law has not implemented any fees for electronic records. So if you have a record that's stored electronically, you just turn it over. There's no fee involved. If you have a paper record that someone asks you to scan and send them, you are not required by law to do that. But once you scan it in, you've got an electronic record and there is no fee. That's your call, but there's nothing that requires you to do that under the law. The thing that makes compliance with some of the records provisions so difficult are those exemptions that I talk about. And this is where we could literally spend hours going over them. Let me just give you a couple of examples. Except as otherwise provided by any federal law or state statute. That means that if there's a federal law or a state statute on the books that said this is a record you can't give out, you can't give it out. It overrides freedom of information. The problem is there's no list anywhere. There's no list of statutes, and so you call me up and I might know of one, or I might be able to find it quickly for you, but there's a chance that I might not. So what you want to do is take a look at the statutes that cover the different records that you deal with on a regular basis and have some knowledge of whether or not there are any exceptions involved. I will go out and do these workshops, true story, and sometimes hear of them that I never knew existed. I did one for the Department of Banking a couple weeks ago. Now, I knew that they had one, but I couldn't remember what it was because I don't deal with the Department of Banking, so I had to go back and look and find that it was 121J something or other, because they've got specific records that in statute say these records do not need to be released under Section 1-200 Freedom of Information Act. There's a law enforcement one that's pretty common. There's a statute that says if you go to court, you've been arrested, you go to court, and the matter is nollied. That's the phrase in the statute. After 13 months, the record's erased. We get calls on that all the time. I got arrested. But if it was nollied, unless you are the person who was arrested, the record's as good as gone. You can't get it anymore. If you're involved in education, there's a federal law called FERPA that says that you can't give out student educational records. And parents run into that all the time. Reporters run into it too, but parents a lot. You can get your own kid's stuff, but if you're looking for something from another child, your kid was in a fight or something like that, you can't get it. It's covered by FERPA. Just a couple of examples that come up a lot, but again, if you can get some handle on it, so you won't be in a position where you're just, you're better served. There's an exclusion in the Act that requires withholding the home address of certain individuals on personnel lists, police officers, judges, correction officers. But that was something that was put in the late 90s, well-intentioned and worked back then. The reality today is that people aren't coming to town halls for those kind of addresses. They're looking us up, they're Googling us, and things like that. We tried for several years to get the legislature to say, look, home address of all public sector employees, just take them off. That's easier. I mean, why would a worker from CHRO, for instance, have an address that wouldn't be released? When people in my office, inmates can make FOI complaints, in case you didn't know. People in our office talking to convicted murderers, their address is out there. There's an inequity there. So we said, take them all off. They didn't want to do that. The legislature did revisit that law back in 2012, and it's clear now that it does not apply to tax records, it does not apply to land records, it does not apply to voter records. So its reach is very limited. But let's suppose you've got a police officer on your Park and Rec Commission, and somebody wants the roster with home addresses, you'd remove at the officer's request, you'd remove that address before you gave it out. But otherwise, again, well-intentioned, served well back in the late 90s, but it really doesn't have a lot of pop anymore. Now that exclusion and the exceptions are required. They're mandatory. So when you run into a record there, it says shall not release, that's it, you're done. The trickier of the three is in section 1-210. That's in the FOI Act, so we can go through all of those if you want. There's 28 of them, and they are tricky because they are what are called permissive exemptions. They are records that you are allowed to withhold, but not required to withhold. So you get a record in front of you and say, gee, does it fall into one of those 28 categories? So you're looking with it, and you say, yeah, I think it does. Then you have to decide whether the public's best interest is served in withholding it or giving it out. You've got to make two calls. So we talk about gray areas, and we talk about interpreting the law. That's a giant area. If you get a request for a record, your instinct is, we can't give it out. And you say, oh, there's an exemption for it, but then you think, well, maybe this is something the public does have a right to. Those are decisions you might have to make on the fly on a regular basis. And the kinds of records in those 28 categories, the exemption for personnel records is in there. There's a chunk of law enforcement exemptions in there. The records that might have trade secrets in them. I mentioned attorney-client privilege. I mentioned bids and RFPs. Records that, if released, would be a security risk. Records that are, you get the idea, records connected with ongoing legal negotiations. If you deal with the public and you deal with records requests, you'll want to look at those exemptions and have some idea what they say and have some idea what's in there, so that if you're ever asked for a record, you have some idea where to look, whether or not there's an exemption. Let me give you an example of just one of them, because it comes up the most. The exemption for things that are in personnel or medical or similar files, and then it says the disclosure of which would constitute an invasion of personal privacy. So the standard for that comes to us from a 1993 state Supreme Court case. It's called the Perkins decision. Perkins was a teacher who objected to the release of her attendance records. The Supreme Court said the attendance records of all of us who work in the public sector are public records, period, end of story, give them out. She evidently had used a lot of sick time and didn't want people to know it. That's the story I heard from 1993. So then the court said, yes, they're public, give them out, and it said to have been an invasion of her privacy, the release of the records would have to have been both highly offensive and not a matter of public concern. It would have to meet both prongs of the test. So somebody wants something in a personnel file, the HR person looks at it and said, would it be highly offensive and not a matter of public concern? If the HR person believes that it would, he or she goes to the employee and says, look, the register's looking for your personnel file. We think it's an invasion of your privacy. And if you say, I don't care, then out it goes. But if you say, yeah, that's right, don't give that out, then the process stops. And the only way the record is released is if the requester files a complaint with the FOI Commission, and the commission looks at the record in camera behind closed doors and says, sorry, Woodbridge, we don't agree with you, no invasion of privacy, give the record out. The person, if it's you, if you're an employee, remember that you only get the right to object if the HR person believes it would be an invasion of your privacy. You only get a heads up if the record's released and there's no invasion of privacy. I get calls all the time from people who say, they gave out my records and they didn't give me a chance. If there's no invasion of privacy in the estimation of the person making the call, then there's no opportunity to object. Let me give you just a little example, a case, some insight as to how that might work. There was a case in Middletown a few years back. Police officer was rumored to be having all kinds of trouble at home, lots of trouble at home. And the rumors got really loud. They took him off the street and they put him on desk duty. They then commenced an internal affairs investigation. So they do the IA report, and like everything else, an IA report is a public record too. The report details things that are troublesome to him at home, but then it also says he's doing a fine job as an officer. They put him back on the street. The Hartford Courant wants to see the report. They want to see the IA report. Middletown PD says, gee, there's a lot about this guy's home life in there. We don't think it's relevant to anything. We think it's offensive to tell the rest of the world. And the public, it's no need to know it because all they need to know is he's a good officer. So they said no. The Courant files a complaint with the FOI Commission, which is its right. They want to see the report. It goes to the commission, and the commission looks at it and says, there's a lot about this guy's home life in here. Wouldn't it be highly offensive to tell the rest of the world about it? And it's not a matter of public concern because he's doing a good job as a cop. It meets both prongs. Complaint dismissed. The report was never released. The key is meeting both prongs. So many times people look for things in a personnel file, and it's clearly highly offensive material because it's about somebody who's been fired or fined or demoted or punished. And the material, the reason that they got there is but then that is a matter of public concern. It doesn't meet that second prong. So people say, how could it come out of a personnel file? That stuff is disgusting. And why did it come out? Because the public had a right to know why somebody was fired, because they were paying his salary. I mean, I'm being general, but you get the idea. The exemption for trade secrets. A lot of people will walk into a town hall and stamp it, confidential, trade secrets, commercial information, don't give it out. There is an exemption for that, but they need to understand that when they hand it to you, it becomes a public record. You can say to them, we will be, of course, willing to try to honor your request, but understand that we have a public records law in Connecticut that may disagree with that. It's not an automatic just because they tell you that it's confidential that you can't give it out. And you need to explain to them that, it's a permissive exemption, and if they don't want to give it to you, now's the time to pull it back. Okay? Records that might be a safety risk if released. The corny example I use is that, we have inmates. The inmate writes to the town and says, can I have blueprints of your prison? It's probably going to be a safety risk. You're supposed to contact the state police, and the state police are supposed to look at it and say, yeah, we agree that's a safety risk. And if the inmate files a complaint, they're supposed to come with you to the FOI Commission to explain. Obviously, they're usually more complicated than that, but that's just sort of a simple example. I want to stress, when I say everything becomes a public record, again, hearkening back to the pandemic, we did then and now do a lot of work at home, don't we? We work on our laptops, we work on our own phones and our own desktops, and I get calls like this. Well, I was working at home, it was my laptop, it's not a public record, right? Wrong. If you create something in the conduct of Woodbridge business, it becomes a public record. It doesn't mean it doesn't fit one of the exemptions, but it's a public record. Just because it's on a private platform or a private device, it doesn't automatically make it something that the public can't get. Especially important for board members when you're emailing back and forth with each other. Again, I stress to you, try not to have the conversations via email that you should be having at the table. Let me share an example to show you This is a new one. This is one of my faves. One of our major cities at the height of the pandemic was conducting a search for a senior legal secretary. So the search is, in fairness, this is hard. It's with the Zoom and the phone and the whole thing. You're trying to hire somebody and you don't even get to shake their hand. So the head of the law department sends this email to a colleague in the middle of all this. I would like you soon to reach out to, woman's name is redacted, on behalf of the law department to thank her for her interest in the position and to inform her that we went in another direction. I feel that you have the most experience in our office handling these types of discussions. Wait for it. After many years of breaking off relationships with your past girlfriends and flings. What are you doing? What are you doing?
It really is a good one.
He titles this email, "Let Her Down Easy, Playboy." Have you learned nothing? One of the clerks gave me a little thing that I have on my desk that says, "When in doubt, don't hit send." He should not have, But you've got to remember, he was, give him the benefit of the doubt. He was just trying to lighten the mood. He was just trying to be funny, if you want. But you can't do that. So now, wait a minute. You're saying, wait a minute, Tom, that's funny, that's great, but why do you have it? Yeah. Because he dropped this email to the colleague while the colleague was conducting a virtual deposition in a virtual open courtroom, and everybody saw it, which led to complaints and investigations and the whole thing. Think before you create a document, of course, but give it a couple of seconds before you hit send. We email each other, we maybe, can you believe you, think. And by the way, I've been guilty of this over the years. When I was on the board, I had one board member, a woman, God bless her, she'd never understood it. I'm sitting at the Freedom of Information Commission, and she's sending me confidential stuff about the Board of Education. What is she doing? Nancy, stop. And then the next day, she fires off another one. We need to fire this one, or we need to, what are you doing? If anybody ever knew that you were doing that and asked for those emails, we're the first place that are going to say, give them out. So again, think before you send, and understand that, yes, it could be exempt, but it's a public record. I'll stop there. I mean, I can keep going, but any questions about anything that I didn't cover? Did we cover the questions that were sort of thrown out there in advance? A couple of them were.
I think so, but if
Yeah.
anybody has any.
Yes, ma'am.
You did say that you have some time to respond to produce whatever they're asking for, but we do have a time requirement as to tell them.
Great point. I skipped that by mistake. 4 business days. When you get a request for records, you need to respond in 4 business days. Respond doesn't necessarily mean produce the records. It means to acknowledge and let them know that you've got it and you're looking into it. If you fail to do that, the law says that you've denied the access and they can file a complaint. So that's a great question. Yes. What else? Any other questions? Any other issues? You can think of anything? No?
No.
We're good?
Wow.
Okay, folks, now what's going to happen is we're going to leave and you're going to say, oh, I should have asked. Remember that we are there to try to help. I have witnesses. If you have a question, if you have an issue, do not hesitate to call. You might get voicemail because we are on the phone a lot, but I will call you back. And we'll answer the question the same way we talked about things tonight. It's not binding, it's not an order, it's our best advice. But I want you to call before something becomes a problem. I want you to call, gee, we're thinking about this meeting, how do we notice that this, I want you to call before it becomes a problem so that we can try to help you through it and you can get on with the business that you have to take care of in town, okay? Guys, thank you very much. All right.